Thank you, everyone, for joining us on the call today. At the White House Initiative on Asian Americans and Pacific Islanders, one of the critical issues that we focus on is the issue of data disaggregation. In the education context, we have formed a partnership with CARE, the National Commission on Asian American and Pacific Islander Research and Education, and have most recently held a convening this year on September 14th and 15th entitled iCount, which is committed to providing more information on data disaggregation in the education context. Out of that convening, we made a commitment to gather the resources at the Department of Education to disseminate information, especially technical assistance, to aid community-based organizations, states, and LEAs on the issue of data disaggregation. I'm proud to announce today our first webinar in this series, which will focus on data disaggregation and Ferpa. With that, I'm very honored to have Michael Hawes, the Statistical Privacy Advisor at the Department of Education, with us to run through a PowerPoint presentation on this issue. As a reminder, this is a conference call and a webinar, so please join us on the webinar and follow along the PowerPoint presentation. Michael, I'll turn it over to you.
Thank you, Akil. Good afternoon, everyone. As Akil mentioned, my name is Michael Hawes, and I'm Statistical Privacy Advisor at the U.S. Department of Education. I also oversee our Privacy and Security Technical Assistance operations, including our Privacy Technical Assistance Center, which I'll give you some information on towards the end of the webinar that can assist you with any additional questions you might have after today's discussion. Just a quick overview of what I'm going to cover. I'll give kind of a very quick overview of FERPA and student privacy, and then discuss how you can share data under FERPA, both when and how you can share raw data without privacy protections. And then for those situations where sharing the raw data is not possible under the law, I'll also cover how you can protect privacy in data that you are publicly releasing or reporting publicly. I'll conclude with some available resources that can assist you with further issues on this subject, and then we'll open it up to a few questions at the end. So just to start, the U.S. Department of Education's role in protecting student privacy is multifold. First and foremost, we administer and enforce various federal laws that govern the privacy of student information. This includes the Family Educational Rights and Privacy Act, or FERPA, and the Protection of Pupil Rights Amendment. But beyond just enforcing these laws, we also see it as a core function of ours to raise awareness of various privacy challenges involving student data, and to provide technical assistance to the education community, including schools, districts, states, colleges, and universities, on how best to promote and protect student privacy and data security. To start really quickly, the Family Educational Rights and Privacy Act, FERPA, was passed in 1974, and it gives parents and eligible students the right to access and seek to amend their education records. It also protects any personally identifiable information, or PII, from children's education records from unauthorized disclosure, and it requires written consent from the parent or the eligible student before sharing PII unless an exception applies. Now, there's a few terms in that need a little bit more definition. The first is personally identifiable information. I always joke that if you ask 10 privacy professionals to define PII, you'll get at least 15 definitions, and FERPA is no different. FERPA has its own definition of PII that differs from how PII is defined in other laws. It includes some of the usual suspects, things like direct identifiers that have kind of a one-to-one relationship to an individual student. These include name, social security number, student ID number, and so on. It also includes your indirect identifiers, those data elements that may have a one-to-many relationship to an individual student, like birth dates, various demographic information, and so on. These may not uniquely identify a student, but can allow you to narrow the list of potential students it could refer to and help you kind of hone in on a specific individual. But unlike many other laws, FERPA also includes a third component to its definition of PII, and that's any other information that either by itself or in combination with other information is linked or linkable to a specific student that could allow a reasonable person in the school community who doesn't have any personal knowledge to identify the student with reasonable certainty. And so this is what makes protecting privacy for students very challenging in many cases, because it means that there's no set list of data elements that are or are not PII, and we often have to look at each piece of information we're looking to release in context to see if it could be identifiable, if it could be linkable to a student. And this is very important when we're talking about public releases. The other thing that we need to talk about is those exceptions to FERPA's written consent requirement. So remember, FERPA protects PII from education records from disclosure without parental consent unless an exception applies. There are a number of these exceptions. They include things like disclosures for health and safety emergencies, directory information, and a number of others that are defined in the law and the regulations. Beyond those exceptions, however, the only way you could release information from students' records would be if it is de-identified. It's important to know that, it's a common misconception that there is a research exception under FERPA. There is no research exception under FERPA, but there are several exceptions to the consent requirement that permit research for certain types of things. The two most commonly used for research are the studies exception and the audit and evaluation exception to parental consent. The studies exception allows disclosure of PII from students' education records for certain studies that are either for or on behalf of schools, school districts, or post-secondary institutions that either develop, validate, or administer predictive tests, administer student aid programs, or seek to improve instruction within the schools. So this is kind of fairly narrow types of purposes that these studies can have. There's also a requirement when using this exception to have a written agreement with the organization that would be receiving the data, and that agreement has to meet certain requirements. Those requirements include specifying the purpose of the study, the scope and duration, and the specific data elements that are going to be disclosed. And that written agreement must also require that the organization receiving the data only use any PII they receive to meet the purposes of the study, that they limit access to the data only to those with legitimate interests, and that they destroy the PII upon completion of the study and specify a time period for that destruction. The other major exception for sharing PII from student records without consent for research purposes would be the audit and evaluation exception. And this allows PII to be shared without consent for certain audits or evaluations with certain authorized representatives of FERPA-permitted entities. This includes the U.S. Secretary of Education and state or local educational authorities. Again, there's a requirement that there be a written agreement to do disclosures under this exception. Also, to use this exception, the evaluations can only be for an evaluation of a federal or state-supported education program or to enforce or comply with federal legal requirements that relate to those education programs. Now, under the law, education program is very broadly defined, but it isn't limitless. It includes everything from early childhood education to adult education, and it includes education programs that are not necessarily administered by a federal or state Department of Education. So it could be an education program administered by a labor department or a health department, but it does have to have education as its primary purpose to qualify under the law. Again, disclosures under FERPA's audit and evaluation exception must be done under a written agreement with the receiving authority, and that agreement must designate an authorized representative, specify the specific data elements that are going to be disclosed and for what purpose, describe the evaluation to make it clear that it falls within the definitions of the exception, requires that the authorized representative destroy the data upon completion and establish that time period, and also that agreement must establish policies and procedures consistent with FERPA to protect PII from further disclosure and unauthorized use. So what does this all mean in the context of sharing disaggregated AAPI data? Well, what it really means is that for much of what you may be seeking to do, for many of the types of research and studies you're looking to perform with these disaggregated data, you can share raw individual level or disaggregated data about AAPI communities without consent and without any privacy protections, so long as it's under either FERPA's studies or audit and evaluation exception, and so long as it meets the various restrictions and criteria that we just discussed. If, on the other hand, you want to disclose information about these communities more broadly or for purposes that don't fall within the requirements of those exceptions, then you will need to look at applying privacy protections to the resulting data before you release them. And those privacy protections usually fall in line with various statistical disclosure limitation techniques, which we will talk about. So you might ask, well, why are we talking about PII? I'm only interested in releasing aggregate data tables. Well, it's important to remember that aggregate data tables can still contain PII if they are data about small groups or individuals with unique or uncommon characteristics. This is often thought of as the small cell problem, where you have data broken down into a number of categories with very few individuals in each. You can usually pick out specific individuals, even in aggregate data tables, when you have those small cells. So what are states doing about this when they're releasing data? Well, under ESEA, states had to adopt minimum N size rules to protect student privacy in all of their public aggregate reporting. But, as you can imagine, there's substantial variation across states on which minimum N size they picked. And this table here is a couple years old, but it shows how the distribution of minimum N size played out across various states, with everything as low as 5 in some states to as high as 30, but with most states kind of adopting a minimum N size around 10. But it's also important to know that in addition to variation in the minimum N size requirements across states, there's also substantial variation in how states have interpreted and implemented what that minimum N size standard means. And we're going to talk about that in a second. But before we do, we have to remember that small cells increase your disclosure risk. The smaller the cell, the easier it is to pick out a specific individual and re-identify them in an aggregate data release. But with all the focus on minimum N size rules, it's important to remember that just suppressing or redacting out those small cells may not be sufficient to protect student privacy, and I'll show you why. Here are some common mistakes and pitfalls that occur when people rely on minimum N size standards in their public reporting. So the first is to confuse population size with cell size. So let's take a case where, let's assume you had a minimum N size rule of 5. And here we have very simple idea for a data table here. We're looking at number proficient and percent proficient for the AAPI subgroup. So there were 6 students tested, which is more than the minimum N size of 5 in this hypothetical case. 1 student was proficient, and that equated to 16.7% proficient. Well, the way some states have adopted their minimum N size rules, they could publish this. But the problem is that this doesn't really protect privacy, because imagine you're that 1 student. You now know something about all the other students in your subgroup. So in this case, the population size met your minimum N size rule, but the cell size didn't, because the cell size of 1 allowed that 1 person to know something about all the others within the group. So there's a distinction between population size and cell size that's really important when we're talking about public reporting. Here's another common mistake. If you look at this list of numbers, what's the missing number in the column? Well, there's no way to know, right? Well, how about now? In this case, it's a simple matter of subtraction. You subtract the reported data from the total, and you know that the missing number is 4. Well, this is kind of a simple problem, but it's one that we see a lot in public reporting of student data because with minimum N size rules, people often will suppress the small cells if they don't meet your N size rule, but they're still reporting the other cells and they're reporting the total. So subtracting out the other reported values from your reported total makes it very easy to figure out what the suppressed value is. Well, you might think, well, okay, let's suppress the small number, the one that doesn't meet your n size rule, and suppress the total, right? Essentially censor both of those data points. Well, that could be a solution, except for the fact that these data are often reported in multiple ways. So imagine a situation like this, where you've got your AAPI students by subgroup. You suppress your small number and you suppress your total, but the total number of students is also reported separately as AAPI students by gender. So all you'd have to do is add those two numbers, and you have the total that you can then use to subtract out and get the 4, which was your suppressed value. So this is a case of just suppressing the small number isn't sufficient to protect privacy. You have to do something else to do it. And that additional step is often called complementary suppression. So let's look at this in a case of a hypothetical table here. Let's simplify things, and let's say you were looking at only reporting data on 2 subgroups within the AAPI community, Chinese and Laotian. Well, in this case, again, we've got proficiency levels on, let's say, a state-provided test. And you've got the number of students tested and the 4 outcome categories. Now, in this case, the Laotian community did not have enough students to be reported, so they are all asterisked out, meaning they're suppressed. But we have all of the outcome information for the Chinese subgroup and then the totals for all Asian. Well, this is a simple matter to undo because you can notice, okay, you've got 11 students in one subgroup, 1 in the other, leading to 12. And you've got a difference in the outcome categories, the outcome categories for the various 4 proficiency outcomes. So it's a simple matter to realize that that one Laotian student fell into the basic category, and you just provided information about that one individual. So just suppressing is often not sufficient if you are also reporting totals or if totals are available elsewhere. A third common problem that we see in public reporting that involves either small or extreme values is relying on fixed top and bottom coding thresholds. So here's a case where, again, we're reporting number proficient. We've got 8 students tested. Let's say the number proficient, the cell, wasn't large enough to report, so they asterisked it out. But they reported the percent proficient as a bottom-coded range, saying less than 5%. This is very commonly used. Less than 5% or greater than 95% are commonly used thresholds for these extreme values to protect privacy of those at either end of the distribution. The problem here is that less than 5% out of a population of 8 doesn't really help you protect privacy at all, because 0 out of 8 students is 0%, 1 out of 8 students is 12.5%. So if you had less than 5% of 8 students, you had 0 students. So it looks like it's protecting privacy, but it isn't really doing anything in fact. What you need to do in these cases is adjust the scope, the range of your top and bottom coding to match the size of the subgroup you're reporting on. So smaller subgroups have much wider thresholds, much larger thresholds for these top and bottom coded less than or equal to or greater than or equal to percentages at the extremes of the distribution. Which brings us to kind of summary. There is a trouble with simple reliance on cell size rules as your way of protecting privacy. It's not just the small cells that are important. Bigger cells or bigger values can still be very disclosive of individual students' information if they are either extreme values, close to 0% or 100% of students in the subgroup, or, and this is even more important, if they can be used to calculate the values of other protected cells elsewhere, either in the same table, in related tables, or even in data releases by another organization. So we have to think about disclosure avoidance in publicly reported data much more holistically, and it's much more complicated than it appears when you look at just simple minimum n size rules. And this brings us to take-home point number 2. Whenever you're performing a disclosure risk analysis, educational agencies and institutions must consider data releases that are made by other organizations. Many different organizations release related data, and those data interact with each other. So how you protect the data at your level has to be compatible with how it's protected at the district level, at the state level, at the federal level, and this can be rather challenging. So just remember that how you're releasing data needs to be taken into consideration with how others are releasing the same data. People often ask me, like, what's the magic number when you're doing disclosure avoidance? Like, how do you do it so that there's no risk? The answer is the only foolproof way of never having any risk in your publicly reported data is to never publish any data at all. And that's not an option. We have to come up with kind of risk assessments that give us kind of manageable levels of risk of re-identification while still being able to publish usable and useful data about students and student populations. But not all data are created equal. Disclosure avoidance is, as I mentioned, about risk assessment and risk mitigation. And different types of data, different categories of data, carry different levels of re-identification risk. And so you have to think about disclosure avoidance in the context of the specific data that you're looking to release. And when thinking about that, you have to think about the characteristics of the data. For starters, is it aggregate data or individual level data? And if you're looking at individual level data, is it a snapshot, a single point in time piece of information about students? Or is it longitudinal, where you're tracking students over time? Are the data categorical variables, where you're broken down into 3, 5, 10 categories of outcomes? Or is it continuous, where there's a huge range of outcomes, like income or age? If you're looking at aggregate data, is it attribute information or outcome information? These are things, does it describe the individual, or does it tell you something about how the individual performed? Is it a single metric about the student, or is it a composite index that takes into account a number of metrics? Is the data a count of students or a count of incidents? This can also impact the re-identifiability and the disclosure risk. And lastly, are the data thresholds or are they averages? These also impact the likelihood that you can re-identify somebody from the resulting data. At the end of the day, the definitions of your data matter. And so you need to factor all of these into consideration when you are looking at the disclosure risk of a particular release and identifying what privacy methods to apply. So if we're talking about risk, well, then we have to ask, well, what's an acceptable level of risk? Well, that's where Ferpa's Confidentiality Standard comes into play. I mentioned in the definition of PII before those reasonables that showed up in there. Well, this is what the Confidentiality Standard is. It's, can a reasonable person in the school community re-identify the individual with any reasonable certainty? And how you assess this is going to differ, again, depending on the type of data. With tabular aggregate data, a small degree of uncertainty, call it reasonable doubt, is often sufficient to protect privacy. We often use the rule of 3, where you break your data down to the absolute smallest level of disaggregation and make sure that you can't pick out a specific student with any certainty over 2 other students in that same subgroup. So essentially blur things so that each student falls into a group of 3 possible students. If you're looking at individual level data, however, it's much more challenging because the abundance of data points in individual level data and the availability of very easy to use data manipulation and data mining tools make it much easier to piece together a lot of pieces of information about a student and re-identify them either probabilistically or with certainty. So you have to adopt a much higher threshold of acceptable risk when you're looking at individual level data. So I talked about the challenges and the problems that people often face when they're looking to do public reporting. So let's look at some solutions. How can you actually adequately and reasonably protect privacy in public reporting? Well, there are 3 basic flavors of disclosure avoidance that you can use. There's suppression, there's blurring, and there's perturbation. And the method you use is going to depend on what you want to use the resulting data for, what the intended uses and reason for releasing the data are. The first, suppression, is the one that's most commonly used in the education community, and it's also the one that we've seen the most problems with, as I illustrated before. Suppression essentially involves removing data from the table or from the data release to prevent the identification of individuals in those small cells or individuals with unique characteristics. And this can be done through cell suppression, row or subgroup suppression, sampling, and many other types. Well, what effect does this have on the usability of the data? Because any time you apply a statistical disclosure limitation method, you're going to affect how the data can be used. And different methods impact that usability differently. So in the case of suppression, the effect on data utility is pretty substantial in many cases. It results in very little data being releasable for small populations. And it often, in order to do properly, requires suppression of additional non-sensitive data through complementary suppression to protect those small cells. What you often end up with when you're using suppression as your sole means of protecting privacy is what we call kind of Swiss cheese data tables, where there's holes all over the place because you needed to protect this cell, and then you needed to suppress that cell to protect the cell from re-identification, and it goes through the whole table. This can make the usability of your data releases very problematic. And furthermore, suppression by itself also carries a relatively high risk of re-identification because suppression is very difficult to implement correctly, particularly if you're talking about large multidimensional tables. And because the data that we're talking about are often released by multiple organizations, it can be very difficult to make sure that the cells that you're choosing to suppress aren't being released by somebody else in a different source or in a different way that could then be used to undo all of your protections. The second primary method of disclosure avoidance is what we call blurring. And this involves reducing the precision of the data that you're releasing in order to reduce the certainty of re-identification. So you're releasing more data, but you're reducing the precision and certainty of the data that you're releasing. And examples of this are aggregation, which can be aggregation across grades or across schools or across counties. It could be aggregation across time even, like instead of releasing data for 1 year, you release data for 3 years pooled. It can involve releasing your data as percentages or as ranges of possible values. It can involve top or bottom coding like we talked about before if done appropriately. Or it could involve rounding to the nearest 5 or 10. Well, what effects does blurring as a method have on the usability of the data? Well, the challenge here is that blurring, by reducing the precision of the data, can make it so that users won't be able to make inferences about small changes in the data, and it can reduce the ability of data users to perform time series or cross-case analyses if, for example, if you're using aggregation, if you're aggregating differently in one location versus another. So in the case of AAPI, the challenge with blurring is you may not be able to measure small changes in small populations over time because those changes may get lost to the blurring effect, either the rounding or the aggregation. What is the resulting risk of disclosure when using blurring techniques? Well, it's generally low risk, but there is still some risk available if your row and column totals are published. Then it may be possible in some cases to calculate out the exact value of an otherwise blurred cell. But it's typically much more privacy friendly as a methodology than suppression is. Lastly, the third category of disclosure avoidance is what we call perturbation. And this involves making small changes to the data to prevent identification of individuals with unique or rare characteristics with any certainty. Essentially, you know that there's some noise or error in the data, and so that increases the uncertainty that you can pick somebody out for certain. Examples of this include data swapping, introduction of noise or error into the data, or the creation of synthetic data that mirror the characteristics of the data but that are derived synthetically. What effect does this have on the usability? Well, it can really minimize the loss of utility when you compare it to other methods. And this is why this is a preferred statistical method for many of the statistical agencies out there, like the Census Bureau or the National Center for Education Statistics. But when you're talking about accountability or program performance data, there's a transparency concern here, because you are introducing some error and you are manipulating the data to some degree to protect privacy. So the credibility and the transparency can suffer if not messaged appropriately. What's the residual risk of disclosure for this method? Well, there is some risk if people had access to the specific algorithms used or the swapping rates that are used. But generally speaking, these are pretty safe methods to use for disclosure avoidance when appropriate. So we've got these three broad categories of disclosure avoidance. All three have their advantages. All three have their disadvantages. So how do you choose? Well, the best approach is to start with the data. What do you want to maximize about your data? Do you want to maximize coverage across subgroups at the expense of precision? Do you want to maximize precision of the data at the expense of coverage? Or do you want to strike some balance in between? You can certainly use multiple methods in combination. Use primary suppression of your very small subgroups and protect that through the use of a small amount of blurring in your others, or rely on a degree of perturbation and rounding. You can definitely mix and match in order to find a method that maximizes the particular utility and usability of the data that you're seeking to provide. I do recommend, if you are going to rely on suppression as your sole method of privacy protection, be really careful. Be really careful of your row and column totals. Be especially careful of how the data are being released elsewhere. And be aware that if you're relying on suppression exclusively, then you will probably need to suppress additional non-small cells through complementary suppression in order to protect and prevent those very small cells from being recalculatable through the other reported data and your totals. Recommend whenever you're reporting in percentages, try to round to whole numbers. It makes it easier to protect privacy that way. And if you are looking to release individual level data publicly, you're probably going to need to use some level of perturbation to protect it, just because individual level data releases require a higher threshold of disclosure avoidance. And lastly, whatever method you choose in your public reporting, be sure to audit the results. Apply your method and then try to break it. You'd be surprised how often a method looks great on paper, but when you then actually generate some tables, how easy it can be to just reverse engineer either your suppressed or your blurred cells. So definitely try to hack your own methodology and see if it actually holds up. So I mentioned in my introduction that we have the Privacy Technical Assistance Center here at the Department of Education. PTAC, as we call it, is a great resource for the education community on issues relating to disclosure avoidance and public reporting, and also on data sharing of student information. We've got a very substantial toolkit of resources that include issue briefs, checklists, frequently asked questions, case studies, webinars, and so on. It's available on our website, ptac.ed.gov/toolkit. The link is on the screen. We also offer a help desk. So if you have questions that the resources online just don't answer, or you have a particular challenge that you need a response to, send in an email to privacyta@ed.gov, and we've got a large team of experts who can help out and try to find the solution that's been vexing you. We also offer, on occasion, on-site assistance to educational agencies and institutions. We do site visits, we do on-site trainings, we do conference presentations and the like. So if you need privacy training or disclosure avoidance training, let us know and we may be able to assist. Of particular note for disclosure avoidance and public reporting, 3 of the resources that we do have online are linked on the right here. We've got an FAQ on disclosure avoidance. We've got a glossary of basic terms used in data de-identification, and we've got a case study that really looks at how and when you apply disclosure avoidance to data that you're releasing publicly. So with that, I'm going to turn it over to Akil for some questions.
Thanks, Michael. Really appreciate the content, and I think it hopefully answered a lot of questions from folks who are participating today. Just for everybody who's on today, we will send this PowerPoint presentation in the next couple days to all of you who have provided your contact information. As a reminder, please provide your contact information to via chat on the WebEx to the WHIAAPI name. So one of our colleagues is handling that, and we can send the information out to you. Additionally, we'll also send out useful and relevant links that Michael has included on his PowerPoint presentation, as well as additional items.